What's up, everybody? Welcome back into another episode of The Lawyer You Know. And we are breaking down the first defense witness. The defense has started their case in chief. We're going to talk about the arguments. Should the judge have just thrown this case out? Should she have agreed with Alan Jackson and the arguments he made? We're going to break those down. We're also going to talk a lot about Hank Brennan's cross style. How is he going to cross examine these witnesses? What can we expect? And then, of course, the end of the day, they proffered a witness that was a friend of Michael Proctor, that was in his group chat. Are the defense attorneys indicating they're not going to call Michael Proctor after their opening statement, after everything they've said throughout the entire process, first trial, second trial? Why would they do that? I've thought a ton about the Michael Proctor situation and both sides baiting each other to call him. And we're going to have a lot to talk about after we get through this first witness on whether or not we think the defense should call Michael Proctor after everything we know now. Has that changed? So make sure you guys hit the like button. Make sure you're all subscribed. We are inching our way closer to 500,000 subscribers. It would be awesome to do it this weekend. And if everybody subscribes watching this video, then we will get to 500,000 subscribers. It would be crazy, crazy. So, okay, let's start out with the arguments. The arguments that were made after the Commonwealth closes their case in chief. It happens in every single case. It's called different things. A motion for it must be not guilty or something, a judgment of acquittal, a motion to dismiss, whatever you want to call it, right? People call it different things, but generally what these arguments are doing is after the Commonwealth finishes their case in chief, they should have proved this case beyond a reasonable doubt. I always tell you guys, you walk into a trial, presumption of innocence, you look at the defendant, they are innocent unless the Commonwealth can force me into that guilty bucket. It has to be beyond reasonable doubt, to a moral certainty. They have to get rid of every wavering doubt I may have. I have to be solidified in the fact that I know that Karen Reed or whatever defendant I'm looking at is guilty. And the way they do that is with their case in chief. And if they fail to do that, objectively speaking, that no juror could ever have a moral certainty or be sure that that defendant is guilty, then the judge should say, I got to throw this one out. I can't have a situation where the state's not doing their job, the government's not being held to their burden, they tricked the jury, they oversimplified it to a jury, whatever it may be. And the judge is supposed to stand in the way of that injustice if it were to happen. So that's what a JOA is. That's what we call it here, judgment of acquittal. That's what it is. That's the argument you make to try to get this case dismissed in the middle of trial without even putting up a single witness. And that's the argument Alan Jackson made. And he said, almost like his opening statement, they did not prove a collision. It is abundantly clear there was not a collision. A collision never happened. Talks about the taillight, talks about John O'Keefe's clothes, injuries, etc., etc. He hits some of the elements of second degree, some of the elements of DUI manslaughter. But at the end of the day, he says there's no way any reasonable juror could convict Karen Reed because the Commonwealth has failed to prove a collision. Then we hear from Brennan, who said, this isn't a closing argument. It's abundantly clear a collision did happen. And he also talks about broken taillight pieces, the debris in John O'Keefe's clothes. He talks about intent. He talks about this is, easily enough for DUI manslaughter there. Although the way Hank Brennan explained intent, that she engaged in intentional conduct, driving backwards or reversing while drunk, and created a plain and strong likelihood of death. I was like, so that means anytime somebody backs up, that could be enough for an intentional crime. I'm not sure that's true. Me and my dad talk about this tomorrow night. I think we're going to drop the podcast, either that or Monday morning. But is driving backwards 2 miles an hour really dangerous? What if it was 2 miles an hour? It could be 2 miles an hour now. The state hasn't proven to us exactly how fast they were driving backwards. So that to me is interesting. But additionally, every DUI manslaughter, the way that Hank Brennan is describing the facts of this case, would also be second degree. So to me, why would you ever have a statute that's that's DUI manslaughter if every time you were drunk and intentionally driving backwards or forwards, why wouldn't it always be second degree? That doesn't make any sense to me. Okay. And see the chat is getting a little distracted with my hair. It's not cut. It's just back here. But let's get into this witness. Or Judge Canoni denies it, and this gets denied in 99% of cases. It's got to be very, very obvious for a judge to throw this case out because we want justice, the victim's family. We have a jury system. We don't want to take the case out of the jury's hand unless it is blatantly obvious. And we all knew exactly what was going to happen here. So then we get into Matthew DeSogra. And I will probably mispronounce his name, not purposely, but he is a accident reconstructionist, engineer, EDR expert. Big time education experience. They hit that heavy, as you can imagine, but they didn't really compare him with Shannon Burgess on direct. Wait till we get to cross. He talks about the triggering events and it records additional time and when the actual triggering event is and when it starts, when it stops. We're going to get a little bit of just a couple clips of his direct to see what the purpose was of calling him for the defense. If you guys already watched this or as you watch this recap, tell me what you think the main purpose of Matthew DeSogra's testimony was. Because we all expected there's some firecracker witnesses. We wanted the defense to come out hot. We wanted them to say, here's how you prove there was no collision, or here's Proctor, or here's Higgins. The same way we wanted the Commonwealth. And when I say we, I mean people watching the trial wanting to see a real, true fight for justice. I wanted to see the Commonwealth expert come out and prove to me how this taillight broke. Prove to me how it did not break John O'Keefe's arm. That's what I wanted. And I wanted the same thing for the first defense witness to really come out and prove a point for the defense so the jury goes into the weekend thinking, oh boy, I'm glad we waited. I'm glad we wanted to hear from the defense before making up our mind. Let's listen to this first clip.
Conclusion with regard to that event and the timing following that event.
Based on all the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on?
And you'll hear Alan Jackson, just like we talked about Hank Brennan, leading witnesses a bunch on direct. I do not think they're trying to be, there are some points where all these lawyers are trying to sneak stuff in, okay? Which it is what it is. You think it's admissible. They think it's not. You want to ask this question. They're being nitpicky on the way that you ask it. So you do whatever you can to get it in, whatever. But what I mean is some of these leading questions for criminal defense attorneys who all they do is cross-examine witnesses basically now, it's a lot harder to get back into direct mode. So same way I said it with Hank, I'm sure people are going to give Alan Jackson a lot more grace. I feel like it's the same for most of the time, is that they're just used to cross-examining witnesses, and it's going to take Jackson a little bit and all these defense attorneys a little bit to switch from cross mode to direct mode.
On which report? We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the January report.
Now, did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date. It was issued on, his report was dated May 8th, and I think I was provided a couple days after that. I don't remember the exact date.
So after, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
He's like, I know you're not watching the trial. And then he just says it was the middle of this trial, which is Alan Jackson testifying.
I'll ask you a different question. With regard to the original report, the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Okay.
Sustained. Ask it differently, Mr. Jackson.
What is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Sustained.
May we approach, Your Honor?
Yes.
They do approach, and Alan Jackson eventually gets to ask a form of that question, and DeSogra basically testifies that the last event on the phone, some of this stuff can get very confusing. Some of it can get very boring, which is already kind of opening to my feel of the defense's first witness. You guys tell me, I see you calling him Data Daddy, and it seems like people really like him, and great. He seems like a really good guy, very honest, straightforward, didn't fight for the defense's position, and good education and real expert, but not overly engaging, didn't prove a major point, because this is the way, by the way, if you want to see how frustrating it was that Dr. Welcher said stuff like, that is what happened, these type of experts can almost never do that. They can almost never say stuff like, that is what happened. And it can be frustrating when you're watching a witness and you want him to push it further than he does. But this witness was like, yeah, according to his report, the last basically movement or use of John O'Keefe's phone happened after this triggering event. And the end time of the triggering event is not necessarily the collision now, which I think the state opened the door of. So just track with me, and maybe I'm way off, but track with me and tell me what you think about this. So if the triggering event keeps recording after and before, and they don't know when the triggering event is in that time period, if the triggering event started and ended at 12:32 or whatever, 12:31ish, 12:32, that means the triggering event could have been even earlier than that. The collision could have been even earlier than that. And then that would have been even more time John O'Keefe's phone was in use. But that was the main thing I picked up from him. Took quite a while to get there. But generally speaking, he was there to show that under the Commonwealth's own data, John O'Keefe was still using his phone after the triggering event. And not a bunch more, right? From my perspective. Not a ton more than that. You tell me. I'm going to look at the chat. I want to see what else you guys think he proved. Let's see what else. Thank you to everybody gifting memberships, by the way. That's always awesome. Love to add new members during these streams. He also thought that it would have been even better than just getting one Lexus and doing this testing if they would have gotten multiple Lexuses to test the variance between Lexuses, because it can be different Lexus by Lexus, how long it takes for the infotainment to come on, 3 seconds, 5 seconds, whatever it may be. That could change how you look at these tech stream events. I thought that was a pretty good point by him. But again, is he really saying the Commonwealth should have bought 2 Lexuses? It's kind of wild. I think I saw Ian Runkle say, I didn't expect a witness to say they didn't buy enough Lexuses, which is kind of wild. Regina said, have you ever witnessed a JOA? Yes, we have won JOAs before. Most of them that I can think of off the top of my head have been partial, like on one count in criminal cases. We've also won some directed verdicts in civil cases. So it does happen. I almost lost a JOA on this trial I told you about. It was like the 3rd trial I ever tried. Shouldn't have tried it. The facts did not fit the crime charge, but I was handed the file. I said it was a really good learning experience. We went and we ended up winning. I thought the judge was going to JOA us. The judge went back for like an hour to consider it. Didn't end up JOAing us when I was prosecuting the case. And we went forward and won. We shouldn't have. We lost on appeal. I didn't do the appeal, but the state lost on the appeal. I think that was the right decision. But yeah, JOAs do happen. Very, very, very rare. Like, it's almost like the state attorney should go back there and be punished if they get JOA'd. Because how can you bring this type of case? But I don't mean on this case. I mean, well, maybe on this case, but on cases where you actually lose a JOA. All right, let's listen to the next clip here from DeSogra.
Reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 results in interaction where it's simultaneous. That's the zeros, the present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
So basically, a couple of things. Number one, not overly convincing of what actually happened, but we can't forget. We've got to switch our mindset. It's almost like the defense can wait and do an opening statement before their case in chief. It's almost like sometimes that would help because you're like, okay, you heard the Commonwealth. For them, they had to prove everything they said. For us, we have to show you why they didn't prove it. And this is what he's doing. He's not saying which one is best. He's not saying, 3 out of 30 means the 27 are the correct and the 3 are the wrong. That's not what he's saying. He's saying they all have strengths and weaknesses. It's almost like they all equally could be correct. I feel like he's testified to. And they can't pick which one is. But what you can do is see the majority of them, triggering event happens before phone stops. How compelling is that? I don't know. The 2 and 3 and 5 out of 30 and whatever out of 30, it's like kind of boring, kind of numbery, kind of confusing. So it's like, what's the jury picking up from him? That's what I'd like to know.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the text stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the text stream event?
Okay. Sustained.
Of the 30, what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the text stream event occurred after the last interaction with John's phone? What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, they're sustained.
So stupid for Brennan to strike to object to that. Like, and I get it. You want to win. And I've done the same thing, right? After I've won an objection battle, sometimes I sit down, I'm like, I should let that roll. Like, who cares? It says 3 out of 30, right? The jurors not morons. They know that's 10%. Why do I care if he gets the expert to agree that it was 10%? I don't know why I would care about that. But sometimes you get into the heat of battle and you want to win the objection, prove you're right. Don't let Jackson do what he wants to do. And that's kind of what happened there. All right. And then we'll kind of get to the end of Matthew DeSogra on direct and what the point was of calling him here.
There were 19 prior events. 762-2
Let's stop there. Right.
prior to,
The entirety of Miss Reed's vehicle, correct?
yes,
How many trigger events did you find in the life of the car?
not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by a collision.
And last question, do any of the text stream events or to any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time? Objection.
Ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
None of the dates triggered on that event were triggered by a collision. True statement. We've heard other people testify to the same thing. Now we're going to get to Hank Brennan's cross. First, let me answer some questions. Christy, takes a while for a bruise to form. maybe this prevented it. Too many strange parts to this case. Not sure innocent, but definitely not guilty though. So a bunch of people have said this about the bruise, Christy. And just for anybody that hasn't heard our discussion on it before, one of my biggest problems with that is Hank Brennan is focusing so much on the bruise to John O'Keefe's knee and even the one to his hand. So if bruises could have formed on his knee and his hand, how in the world would they not have formed on his arm? I don't get that. Right? They're all sitting in the same place. They all have one layer of clothing over them. I guess the arm kind of has two over parts of the arm. I don't understand that. If that was the case, why didn't they have the medical examiner testify to, well, we wouldn't expect to see bruising here because he was laying in the snow for 5 hours? I don't know the answer. Kind of like DeSogra. It's like, I don't know, but they didn't prove it. That's how I think about things. DeSogra's like, we can't tell here. I'm not necessarily proving anything to you with my testimony, but what I am telling you is they're not proving anything. Peter, could the first witness be less about strategy and more about schedule? DeSogra mentioned he'll be in Wisconsin next week. Absolutely. And that's what I want. That's why all these people I talk about, what would you do? And it's like, yeah, strategy, come out. You want to lead off with your best hitter. Let's put Ken Griffey Jr. in the top of the lineup, Barry Bonds second. It's like, I get it. Sometimes it doesn't always work like that. And that very well may be the case. Additionally, he is a foundational witness. I don't necessarily think you had to call him before ARCA after listening to his testimony. I wasn't sure what he was going to testify to. I don't really think you had to call him before ARCA. Maybe the defense thought you did. But absolutely, there are different reasons why you call people in. The virtual juror, have you ever seen a JOA succeed? Yes. Very rare, but yes, and mostly in like misdemeanor and lower level cases. I've never seen one on like a charge like this. Karen, the Commonwealth was able to get Buchanan to read Proctor's text because he was on the text stream. Why is this different? Well, Hank Brennan makes a very specific argument for that, and we're going to talk about it together. So I'm going to hold this. Sanford, KR's statement. I saw John go into the house. Why at 5 a.m., wake niece, call Carrie Roberts so frantic, tell Yannetti on the 29th, did I hit him? Could I hit him? Karen Reed, you said you saw him go into the house. Why so frantic at 5 a.m.? It's a good question. And here's what I'll say. Totally fair question. It would be a good discussion between jurors. Does that prove beyond a reasonable doubt she hit him with her car? That's the problem, right? Is I can see if we want to get into the strange things in this case and the behavior of people in this case, including Karen Reed, including other people around, I'm with you. Why do and say a lot of the things that were done and said, including a lot of these interviews? But the state has to prove it to you. Aaron, do you think the defense is concerned Brendan will lead? Hold on, I want to save this. I want to save a lot of the Proctor ones till later. Do you think the jury will notice the fact that DeSogra seems respectful to Brennan versus Welcher acting smug and disrespectful to Alessi? The old fake haircut. I like your style. Yes, this has happened before. Where people think I cut my hair, but I didn't. Here's what I'll say. I need to stop saying that on my own YouTube show where all it is what I say. I hate when I say, here's what I have to say. But I think that's very obvious. I think that was a big deal to those of us thinking about that, to maybe lawyers watching, to you guys watching, to people that didn't like Welcher, to the jurors that just thought Welcher was normal. They probably didn't see a difference. To the jurors that didn't like Welcher's disposition and his demeanor, they're probably noticing how different DeSogra is. This is a good transition into Cross. So we're going to listen to the very beginning of Cross. Hank Brennan comes out swinging. I think with some good questions, hard hitting. You can see this guy's a skilled cross-examiner, but what does he do? What does this good question that makes a very fair point about this entire direct testimony we just heard from DeSogra, what did it not do? Hank Brennan does a good job of pointing that out. There's just one little issue.
Brennan. And Mr. DeSogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on. And the fans, it's a little stuffy in here. So if you just speak directly into the microphone, that would be great.
No problem, Your Honor.
Thank you.
May I proceed?
Please.
Good morning, sir. Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022?
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Mr. Reed's Lexus never got into a collision before January 29, 2022, or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, are you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision.
To suggest.
So I didn't even notice that. We're going to listen to that last question again. But he's like, you're not saying there was no collision, right? You're not proving there was no collision. He's like, no, yeah, that's correct. Ha. It's a great point for Hank Brennan. What did this witness actually prove? Problem is, he's not defending this case. And I know a lot of people have been like, oh, he's a defense attorney. He's been defending this. I don't necessarily think he's done that the whole time. But with this witness, with that hard-hitting question that really made a point, it's like, brother, they don't have to prove that. That's not why he's here. Now, is he going to try to twist this? If I'm the defense, just after this witness, I'm going to be very careful about objecting in sidebars, arguing Hank Brennan burden shifting. Because, Judge, he doesn't have to prove that. So he needs to be careful about trying to tell the jury our witnesses aren't proving things. But listen to this one again. Listen to this last part again.
Collision. And that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision.
He said there's no data on the text stream to suggest a collision. That was from Hank Brennan. Hank Brennan said that. I didn't hear that the first time. Zizi said, no one saw a body from 1230. How is this possible? I agree, but I do think that was a way more apparent point in the first trial than it has come out in this trial.
Text stream data can be triggered by a number of different things other than a collision. Isn't that true?
Correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right. Right. So there's other things that will trigger text stream data.
Correct.
Like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexus calls a PCS, or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know a lot about text stream data?
Yes.
And you're saying that if a car accelerates over 30%, in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
if someone,
That's a little bit crazy. That not a big deal, right? But if she's going to let him like repeat big chunks in his own words and then say, now I'm asking you, it's a little too much wind up. And Judge Canoni allowing that, she's opening up Pandora's box with these lawyers. She should just be like, Mr. Brennan, ask the question. You have a question, say, did you just say this? And he says yes. Then you ask your next question. You don't say 5 things in one question, right? That's what makes the lawyers testify, right? Everybody's like, oh, what the lawyers say is not evidence. Lawyers aren't testifying. Well, then stop them from testifying. And all of these lawyers want to testify. And this is the reason they're kind of pushing this, because she's allowing it.
accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers. There's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, is that, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point. No.
So we also have to remember he didn't do a report. He's not looking at a computer. And Hank Brennan this is also going to be a style of Hank Brennan's. I think I'm learning his style, right, as we go, because different lawyers do different things. And again, I don't hate it. If the guy doesn't have his report, doesn't have notes, doesn't have his computer, right? There's going to be people in the chat being like, oh, look, he did so much better without all this stuff. And there might be some jurors like that. There's also people in the chat like, this guy didn't know what he was talking about. And I think there's going to be some people on the jury like that. And when you're a lawyer, sometimes you want to highlight that. And so Brennan, knowing this guy doesn't have a report, knowing he doesn't have a computer, knowing he doesn't have notes that he's referencing, and the jury may think that's cool. Brennan showing off his knowledge a little bit of the case, that he has all these times and things memorized. He's going to ask this guy specific questions that he knows this guy's going to say, I don't know to. He knows DeSoger is not going to know some of these specifics. First off, they don't matter. Most of them are not important. But if you can ask questions, and I'm trying to tell you the strategy of what lawyers are doing on cross sometimes, because sometimes it can't be obvious, or sometimes it's not obvious, I should say. But he's making him say, I don't know to a lot. And DeSoger is not flustered by it at all because he's like, that's not important. But Brennan is trying to make it look like a jury that Welcher and Burgess, they knew all these answers. They studied it. They did the work. They did the reports. They were there. They could answer anything you got. And if they couldn't, they just had to take 5 minutes to reference their materials. Very different vibes. And depending on the juror, I think that depends on what. Did you notice that? And what is it? How do you compare Burgess? Forget about the educational stuff. Okay, I know how everybody feels about that. But Burgess and Welcher to DeSoger in the way that they would find the specific answer for everything, and DeSoger's just kind of like, yeah, I don't know. I don't know that specific. I don't have that written down. I didn't memorize it. He has him confirm he's not a cell phone expert. Never testified about mobile forensics. The fact that he's only testified one time in court, I thought was interesting because he had a really, really good resume. I'm surprised he's only testified as an expert in court one time. And I think if this was a Commonwealth witness, a lot of people would have hit that fact because the Commonwealth witnesses have testified a lot more. But I also thought it was weird that Brennan confirmed he's not a cell phone expert and then tried to ask him all these cell phone questions as if to prove he's not an expert, where I was like, come on, man. Like, the guy told you he's not a cell phone expert. What are you doing? I didn't stop him, though.
Offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Ms. Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
Did you ever do any actual testing in this case?
No.
And so
And by the way, I think that's a fair line of questioning as well. He didn't need to. It didn't matter. That's not what he was here for. And Brennan even confirmed, he's like, I think this might be the spot where he's like, you just criticize other people's reports. It's like, yeah, but once you confirm this, Brennan hit this point like 5 times that he didn't do any testing, that he was just looking at other people's numbers. And then I think it comes back to bite Brennan at the end. I thought the beginning of the cross was much better than the end because a lot of what he set up in the beginning that I thought was good, it fell apart a little bit at the end.
your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
My clients in this case.
You what?
Mr. Jackson, my client.
Did you ever speak to me?
No.
I also don't like when he says Mr. Jackson, my client. That's a peeve of mine. Maybe it's different in Massachusetts. Maybe it's different in California. Karen Reed's the client, right? Because Karen Reed's paying him. Alan Jackson's not paying him. The money is coming from money that is either Karen Reed's, directed to Karen Reed. Alan Jackson's not taking money out of his own pocket paying for it. So that's always a little, makes it seem like, are you in bed with this lawyer if he's your client, not Karen Reed? Are you doing what this lawyer tells you to do and what's best for this lawyer?
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess.
Correct.
Report by Dr. Welcher.
Also correct.
Reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
I did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about. You're just critiquing written reports.
Correct.
Well,
I think Brendan was almost a little surprised that DeSogra agreed with that, but he's like, yeah, dude. And the other thing I liked about DeSogra personally, I did not think he was like some superstar witness personally. If I needed an EDR expert, he's great. I loved how he would give what you needed to give on cross. It took some of the sting out of what Brendan was trying to do. It's like, yes, that's exactly what I did. Clarifying, criticizing, whatever you want to call it. Yes, I looked at other reports and then I looked at, did they do this right using their own data? Which again is exactly where Brendan kind of loses the hook at the end when he really starts crushing the data, like Nathan said here. I was very surprised at how Brendan conducted his cross. So much of it felt like he wanted to impeach the testimony of his own experts, not just the testimony, but their data. Finally caught a live from Scotland. I live near all the major golf courses, Peter. I've been there one time in my life. Best golf trip of my life. Probably will be the best golf trip of my life till the day I die. Brendan seemed to allow this witness to answer more than a simple yes or no without cutting him off at times, because I honestly think that's mostly because this witness wasn't trying to push stuff. He wasn't trying to advocate for the defense. He was just, everybody, this is also a good thing about an expert. Everybody knew what this guy was going to say because he was consistent and he stuck to his PowerPoint, his opinions, and what he said. He didn't change things. He didn't add things. He wasn't trying to argue with Brennan. That's why Brennan would let him answer. My opinion.
as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it.
That was one of my favorite parts. I wouldn't commission work without being asked to do it. As is how you should be with an expert. You don't just unilaterally create a new report and send it over to the lawyer and bill them for it, right? I don't know if that stuck out so much to the jury. I may have brought it up again on redirect if I was Jackson, but it's like, yeah, we don't usually do that in this field. He talks about when he got the reports, kind of the timelines. Brennan really tried, and I want to see somebody had a question about this. He really tried to get this witness to say, Burgess is a genius. Burgess did such a great job. He's a hero. Were you impressed by Burgess? Brennan would say things like, don't be shy when asking, I can't remember, was this when he was saying, did Alan Jackson ask you to do this? Or when did you give the report to Alan Jackson? I think that's when he said, because, the timeline of all these reports is so screwed up. And Brennan, again, call him a lawyer if you want, is going to twist this to make it seem like all the experts turned things in late. All the experts were changing things. All the experts were adding to their PowerPoints. When in reality, everybody was doing it because the Commonwealth experts moved the goalpost. They changed things, so everybody had to respond to it. Let me see here. All right, we'll get into some of the snarkiness from Hank Brennan, where he starts to sound a little bit more like a jerk rather than, I think, a strong, confident cross, which I think he definitely doesn't have Alan Jackson's swagger. Is that still a word the kids use? Aura. He doesn't have Alan Jackson's aura, but I think they have his cross-examination style would be most similar to Alan Jackson if I'm comparing him to somebody on the defense team.
That was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on. The infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes.
Okay. Now you've made some slides and you've made some assumptions suggesting that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welch's report.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welch's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welch's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically, he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report?
That's the lack of aura and swag. Like, he wants to disagree with you, but he's like, that is exactly not what he said. But it's like, this is where he can't help to battle. It's like the first thing this guy has pushed back on. I think DeSogra was very neutral, very calm, just here to do his job. I don't think anything that Hank Brennan asked him was really unexpected. I think he knew he was going to hammer the points that he knew, and he was just like, that's not what I was hired to do. That's kind of what, did I already put Taylor's comment up that said that? Taylor had kind of a nice, it's kind of a nice summation. He's scolding the witness for not doing the work he wasn't responsible for, then put him down for working off the data provided by his own expert. It's a pretty good summation of Hank Brennan's cross, I think.
Second report to say that he doesn't think, basically, he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report? Where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right? So
that is just like, so the other thing about Hank Brennan is when we're talking about, Taylor's comment before again, it's almost like he wants to use what the jury doesn't know in his favor, right? Because the jury's not going to necessarily understand that. The defense's job to make sure they clarify what exactly his responsibility is. So I get that. But Hank Brennan will do that on one moment. And then somebody else was like, virtual juror. Why did you speak with me? Don't like that question. Before that, I was okay with Hank Brennan's cross, but it made me seem overly confrontational for no reason. Again, he wants to make it seem nefarious that the defense experts aren't speaking with him as if they should. Some jurors know that that's not how it works, but others might be like, why are they avoiding speaking with the prosecutor in this case? And it's just like, that's why I would object. I'd be like, Judge, that's not relevant. If this witness spoke with Hank Brennan is not relevant, that's not how this works. There's a little more here.
when you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess' report and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3-second delay.
All right, we're going to jump to the next part. We've been over that a couple times.
Happens almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but
And
not
you're
this specific Lexus.
I'm sorry, finish.
No, I'm clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar, so we don't know.
Well, you don't know that they didn't document that.
To be fair, if they did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3-second delay. It's a yes or no question.
I'm saying we don't know. If had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same or is it unique? We don't know. The answer is we don't know.
And so when you're determining that 3-second variance, you don't have any assurance in your own mind whether or not this car, Ms. Reed's Lexus, has a 3-second variance. That's what you're trying to say.
That's correct. And that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now let's turn to slide 9.
So there was a couple times where Brennan asks, well, you don't know if that testing was done. He's like, well, it wasn't in the report. So are you saying there was testing done that they didn't put anything in the report? We're going to jump ahead a little bit here as well. Yeah, Mego, I noticed that as well. I liked his demeanor a lot. It wasn't his fault that his testimony wasn't captivating and engaging. That's kind of the field he's in. But I think that's what a lot of people were expecting with the defense's first witness. Michelle said, I feel like this witness showed that Burgess was only looking at certain data values instead of considering all of the values. Hank Brennan was super defensive about cherry picking data, consciousness of guilt. I do remember the portion where he's like, that's the opposite of cherry picking data, isn't it? This guy was like, yeah. This guy was not afraid to give the truthful answer, regardless of which side it was good for. Like there were some points the Commonwealth made that he let him make because it was the truth. I like a witness like that. I want the truth to come out. As a criminal defense attorney, prosecutor, however I'm looking at a case, I want the truth to come out. So that would not bother me from this witness. I'm not the type to say, don't give him an inch. I would never do that. I hate the way that feels. Siobhan, oh, Riz? Riz is still the thing. Okay, Riz. Octavio, lawyer, do you think there could be a second mistrial? Absolutely. I think of all the trials I've watched, this would be the one I would say is the highest percentage chance I thought could be another hung jury. I don't think I've ever voted or guessed or thought it was going to be a hung jury in any trial we've watched together or that I've done myself. And I've had 2 hung juries, one civil, one criminal.
Back on how it's synchronized
Hold on. Is this where I want to go? Yeah.
on the infotainment system.
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments, I included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source.
So it says, according to Judy Ron, Brennan's experience is crossing corrupt cops and government officials, and that's the only mode he knows. I definitely would agree Hank Brennan has one speed, but there's no defense lawyer that this is all they know how to do, or that you wouldn't have a job, you wouldn't have a career if this is all you could do is cross dirty cops and government officials. There's not enough cases to have a full caseload and run a firm on just that type of case. Well, maybe I'm underestimating the types of cases in Massachusetts, but Siobhan, hey, Peter, you just made a great point for your presentation. You're essentially teaching 20,000 potential jurors. Those cheap strategies will phase out. I hope so.
Source of them, and you're wrong, that would change your entire analysis and conclusions and charts that we see in your later charts, wouldn't it?
Sure, if there was testing that showed that that is an invalid method on this specific Lexus and SD card, then of the 30 possibilities, some of them would end up being eliminated.
Did you know that when an iPhone is plugged into a car?
So that was just, I wanted you to hear the first of many times that Hank Brennan asks him, if the data you used was wrong, then all of your stuff that you did was wrong. It's like, yeah, but I got the data from Burgess, your witness.
Do you have any opinion about whether iPhones will generally be within 1 to 2 seconds of each other?
You can ask if there's an opinion. Do you have an opinion on that?
No.
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree all of your assumptions and conclusions are inaccurate.
They're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into it. What you're saying that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating, aren't you?
We don't know. It wasn't tested. I don't know is the answer.
Don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know. So this is iPhone.
Like, that's the type of crap. That's the type of stuff, honestly, with my personality, right? Again, I'd never be on a jury, but with my personality, as soon as he said that, I'm out. And this is where we're getting to the end of, or later in his cross, where I'm like, don't say we don't know, you don't know. It's like, brother, what are you trying to do here? What are you trying to do, Hank? Come on. I'm not a fan of that type of style. The beginning, sir, let's just be clear. You're not proving there was no accident, right? You're not saying that this data proves no collision, right? I like that type. It's fine to be firm. It's fine to come out swinging. This is the type of stuff that I don't like. This is where you would lose a person with my type of personality. Carrie said, I appreciate the truth must come out. What is your mindset when you are defending someone who has done something wrong? That must happen too. So yes, here's what I'll say. It's not a situation where every time somebody's like, I committed this crime, can you get me out of it, right? Sometimes it is, and sometimes you make deals. Sometimes you talk to the state and you say, it's a good person, a really good background, first crime, whatever, and you work out a deal. Sometimes you don't know if they did it or not as a lawyer, but you still want the truth to come out about the investigation. What did the cops do? What did they not do? Did they cut corners? Were there issues? Could it have been somebody else? That's still all true. And we can talk about it. And it doesn't just mean you get up there and you say, okay, every defendant has to go up there and confess and spill their guts and say, I did X, Y, and Z. That's a whole other conversation about whether or not that should even be appropriate in certain circumstances with how the procedure and process goes. Going to jump ahead a little more. Actually, let's listen to this one more minute.
We don't know. It wasn't tested. I don't know is the answer. I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Assisting.
So this is iPhone to iPhone. Then your assumption on the first side, 1, 2, 2, 1, 2, 1. If they're iPhone to iPhone and you're wrong about the fact it's infotainment to iPhone, your assumptions and conclusions are inaccurate, aren't they?
I'll allow this.
If the title of the first column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question.
That's pretty much what Jackson gets on redirect. They talk about, there is different variances. They talk about the disparities. Again, I thought a lot of that was confusing, especially because Hank Brennan was like 16 seconds up and 21 seconds down equals 27 seconds. The witness is like, I think that's 37 seconds. A lot of confusing stuff like that. Brennan likes to say, going back to my question, which is a way to indicate to the jury, you didn't answer my question there, sir.
The 5:21 a.m. and 5:30 a.m. are the only two data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Because you still are under the mistaken belief that
Sustained.
you still have the
You are still under the mistaken belief, and then he changes it. He doesn't care that these objections get sustained.
opinion that the first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had, that those points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those
That's him saying Burgess removed the bad stuff and kept the good stuff.
first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
It's stated that way, and I think it could be that way, but it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization.
Okay.
It would change the total number of possibilities.
So if we put up chart 12, page 12, please. If you were wrong about the infotainment to iPhone analysis and those first 5 should not be considered, which part of your chart would now be wrong?
What do we have? 12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
Yeah, I agree with this comment, Gates. Considering this expert was looking at the Commonwealth expert reports, he's not wrong on saying we don't know and we didn't do the testing. I agree. And Brennan goes on for multiple minutes here, going back and forth on what parts of your chart would be wrong if the data's wrong. and the guy's like, a lot of it would be wrong, but I mean, this is your data. Additionally, he does, I think, agree that when there's more time away from a text stream event, that's less reliable to use than what happens closer in time, which I thought was a good job by Brennan. Now let's go to kind of the end of the cross.
Times at the end of the event. Going back to the beginning, isn't that even more forgiving than the date type possession?
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
The opposite of cherry picking, right?
Sure.
Do you have an opinion?
Opposite of cherry picking. That was a good point. Good job by Brennan.
Do you have an opinion to a reasonable degree of forensic data certainty?
Brennan just takes the kind of easy route, and whatever their expertise is, he says that's the certainty. All of this, I think, should be scientific certainty, mathematics certainty, medical certainty. It's not forensic. What did he call it? I don't even know what he said. Data certainty. I've never heard a lawyer do it quite like that, but whatever. If the judge allows it.
About whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is the text stream data would not reflect the collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
I guess Hank Brennan's agreeing that happened.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really
I
hear
don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's
Yep.
19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying
And that's what Brennan's trying to prove. It's like, you didn't memorize all this stuff, did you? Like my witnesses did.
or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustain.
I have no further questions.
Okay. So that's the end of cross. And the first thing Jackson says on redirect, okay, this is the first place Jackson goes on redirect, which I personally loved. He saved it for redirect. Here we go.
A few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen if I could. Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree
Yes.
and you hold a master's degree.
I do.
You ever lied to anybody about that?
No.
I mean, if I'm Brennan and I've done this before and I've been sitting in the chair before where something bad happens, or they needle a hole that's already exists, right? Pick a scab, whatever you want to say. And it's like, oh man, that's the worst. That's the worst. You're sitting over there and they're hammering a horrible part for your case. And Jackson saved it for redirect because he knew Brennan was going to go at something with this guy's credibility, expertise, education, experience, whatever. And he took the opportunity. Heather said, disappointed no recap last night, so I watched Valo recap. You imitating Lori's comments was hilarious. You looked so tired. Happy you were on vacation and resting. Hank was impeaching a witness who used his data. We stayed up so late last night too. So I am a little bit tired, but this is the last video for the weekend, so then I can chill for a couple days. If many vehicles allow you to view your recorded backup footage in live time, wouldn't an expensive car like an Lexus offer that? Did I miss this part? I don't think it records it. So some vehicles do record it. I don't think the Lexus records it. Vicky, sounds like you've got vocal strain. Yeah, a little bit. I worked in radio for 8 years and highly recommend a vocal coach. It could be as simple as changing your chair. I would love that. Yeah, I hate it. It's so annoying. It's so annoying. Good morning. Hope you're enjoying your vacation. We are. Thank you for asking. If you look at the video of Karen leaving One Meadows at 129.22, that tail light looks intact, definitely not shattered. Do you think the defense will call Proctor? Yeah, again, I think the pictures and the videos of the tail light, both sides are going to argue it works for them. I'm going to hold Proctor. We're going to answer that in a little bit. We're about to get there. Hi, Peter. Hair looks great this morning. How much does it matter how likable a witness is? I found Desogra more likable than the Aperture guys. I think it's important, especially when it comes to experts, because sometimes the trial comes down to who do I like more for a jury. It shouldn't, but sometimes it comes down to which side do I like more. All right, let's get through this redirect so we can get to the meat. We've been going an hour. We're doing some overtime, even on vacation. Hit that like button, please, everybody. And make sure you're subscribed if you haven't already.
Mr. Desogra, what is the only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report.
So-
Great point. You have to do that. You have to explain it. So Brennan's making it seem like everybody's changing everything. It's like, no, we're all responding to Burgess's change.
Form of steps taken, 36 steps over the course of 83 feet. Would that change your analysis or opinion in any way? Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12:32:09 to 12:32:16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in time. Let me rephrase that. All of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
The key on it. Is that like a stopwatch? A stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
As a clock,
Are those two things independent of one another?
completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from, is these are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we talked a lot about PowerPoints of Mr. Desogra's PowerPoint. Can you highlight the table on the left, Mr. Walker? Thank you. Did you create this table?
No,
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
it was. It was
Did you type-
it was a screenshot.
Thank you, screenshot. Did you type a single word on this?
I did not. I added a green box.
Put a green box around it?
Yes,
You didn't type anything on this, did you?
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were reflective of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming?
Objection.
Sustain.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection.
Sustain.
The jury gets the point though, right? They keep discussing it a little bit more, but it's like, Brendan just tried to point out all this stuff that you might be wrong about and that you were doing it wrong, et cetera, et cetera. But in reality, if you were wrong, it's just because Burgess was wrong. And I thought that was really strong. And then on recross, Brendan was like, you can't defend the data you didn't gather. It is what it is. At the end of the day, I think Brendan made some points, but the whole like, well, if garbage in, garbage out, it's like, well, your guy was putting the garbage in. So that would mean garbage out for him as well. Okay. Then in redirect, Jackson gets up again. Is like, well, whose data is it? All right. I'm going to answer some questions before we get to the Proctor part of our day. Knowing perjury is hard to prove. What stops Proctor from lying on the stand? Career already ruined. Once the jury hears it, they can't unhear it. Too risky. We know what he's capable of. Thoughts? Of course, I said, I'm going to save the Proctor questions. And then the first one I pull up is a Proctor question. I thought it was a perjury question when I first read it. I don't, his prior testimony, if you have prior sworn testimony, that's a lot easier to prove perjury. So if you're the defense, you're going to stick to what he's testified to, not ask him open-ended questions that you don't know where he's going to go, because I would agree with you. He has nothing to lose at this point, or I should say less to lose at this point. When JC said, ask it differently, does the lawyer know what's wrong with their question when no grounds of the objection? Voice sounds hurt. You okay, Peter? I'm fine. But usually, no. We know there's a problem with the form. So it's either a leading question or needs foundation, or you're asking in a compound way. She's saying it's a form issue and you have to change the form of your question. And it's up to the lawyer to figure it out, I guess, in this trial. Does guilty only happen if they prove it was intentional? Only for second degree. Patio, can the jury know the defense is working pro bono? No, but I don't necessarily know that they are working pro bono as it's defined, meaning they're not going to get payment or delayed payment. Abby, good day. Finally caught you live. New fan from Australia. What will happen if Karen is found not guilty? Will there be a new investigation? Highly unlikely. This is probably pretty much over. Actually, she might file some civil claims, but her case is over if she's not guilty. I think Karen Reed was frantic because John should have been home already at 5 a.m. If I called people I love more than twice with no reply, I would think they are dead. Did something happen to them? I think some people might, some people wouldn't. I could have sworn I saw Karen Reed in a channel commercial on YouTube 2 days ago. Has anyone else seen this? Am I losing it? I have not seen that. Oops, it's a Proctor question. Touche. Can the defense clear up all of Hank Brennan's false insinuations in closing, or will they just linger? He's effectively burden shifting almost. They can clear up as much as they can in the limited time that Judge Cannoni gives them. But that's the hard part. Choosing what you're going to fit into that closing. Michelle C. Do you think that Brennan is extra annoying because he's playing to the cameras, or is he always this disrespectful to other trials? I don't know that answer. I've never seen him in another trial, so I don't know. I think some of what he does definitely is for the camera. Neck, I noticed that most of the experts stop speaking to the jury during cross. It's like jury is just watching on an argument. Thoughts? It can be, but some witnesses do. Sometimes it still seems weird. I think it all depends on the vibe of the witness. It all really depends on the vibe of the witness. Do you think Hank went hard on DeSogra because he thought the jury was with him, or was he just frustrated? I don't think he was frustrated. Honestly, my feel is, it's the first time I've watched Hank Brennan cross-examine during trial. This is going to be his style of cross. I don't think we're going to see sweet, kind, nice Hank Brennan on cross at all. Eli, what's up, Peter? Regarding Proctor, okay, hold on, I'm going to hold this one. If the trial ends in a hung jury, could Bev be the judge for the third time? Yes. If this was to be retried, or can the defense request a whole new judge? They can request a new judge, but the default would be Judge Cannoni. Michelle, will Hank Brennan, while he's questioning Dr. Russell, say dog bite certainty? Oh, I hope not. That one's pretty easily medical certainty, or, oh gosh, we'll see what he says. We'll see what he says. Is it difficult for your personality to represent someone if you question their innocence or feel they're being dishonest? I'm not going to lie. I don't mind representing people that have committed crimes, right? Because there's a lot that can be done. It's not, you don't go up there and say they're innocent, right? You don't go up there and lie. But I don't take every case. I think everybody deserves a criminal defense attorney and for their rights to be protected. And the Constitution says everybody deserves fair representation. Every case does not fit with me. And I pick and choose what cases that I would handle, which is different than what my dad would handle and what JD and other people would handle as well. Nicole, I'm a hairstylist. This case was the talk of the salon yesterday. Everyone said not guilty because of the investigation. And then I shared your YouTube channel. They all started watching your videos. Thank you, Nicole. Thank you so much. I thought this was going to go somewhere else when you said you're a hairstylist. Saying something about my hair today has been a bit of a distraction for the chat. Okay, let's get into, they proffer a witness who said, I'm friends with Proctor. I was on the group text. I can confirm which one is Proctor. Brennan gets up and says, do you have an independent memory of this conversation? He says no. And that is Hank Brennan's main argument as to why these witnesses should not be able to be called to get Proctor's text in. So these witnesses do not guarantee that Proctor's text would not come in, but it is an option. Sorry, these witnesses, if they're called, don't guarantee that they wouldn't call Proctor. But it's definitely setting up like this when we see these arguments and hear these arguments that sounds like the defense doesn't want to call Proctor either. So they got the witness on the stand. They did the proffer. Now we're going to listen to the arguments made by the lawyers.
Principles that the Commonwealth cites. It's three principles. It's almost like Commonwealth versus Sullivan. Geez, this is a Bowden issue, and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by.
She's like, I've read the text message. She's like, Judge, if I'm going to win, I'll sit down right now. It doesn't sound like you're just going to tell me I'm going to win. So I need to make my argument for the record to make sure you fully understand.
Insults.
Okay. So I won't even mention them then. The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not.
Which I think is the best argument against hearsay. These insults, we're not saying they're true. The Proctor text messages, they're saying, oh, hearsay within hearsay within hearsay. Hearsay has to be an out-of-court statement used for the truth of the matter asserted. And then there's all these exceptions, of course, but if it's not hearsay, you don't even have to get to the state of mind exception, to the police investigation that he was using it to do X, Y, or Z. We were just using it to show his bias, to hit his credibility. You don't even have to get into those exceptions if it's not used for the truth. The virtual juror said, AJ said they wouldn't collect. Listen, I'm not going to call anybody a liar. I don't know what their arrangement is. Why would you be keeping the number that you're billing if you're never going to collect? I don't know. Additionally, if there's some movie deal or some money that comes in afterwards, these lawyers deserve to collect, in my opinion. So whatever, they can do whatever they want. No, the jury's not going to know about the billing arrangement.
Not. Hearsay has three components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner is not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead.
So that one, I think, if anything, they are trying to use that to prove the truth of the matter, that the homeowner is not going to catch any grief. I actually think that one is potentially a hearsay statement. So you might have to parse some of these out. But I do think it falls under the exception of state of mind and why he made the next steps.
Lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator.
And nothing would be hearsay ever because it's just showing your state of mind. So I disagree with that argument because then I could say the sky is blue. It's like, well, I just want to say that. I just want to have the jury hear that Peter thought the sky was blue. That's just what's in his mind. It's like, no, you're probably using that to prove the truth of the matter asserted in a case about what color is the sky.
Investigator
his bias in what he does or doesn't do. And in fact, Mr. Brennan said in sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's going to go down for this. We're going to pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed in the.
And Brandy on her Twitter, 13th Juror, if any of you guys follow her, she posted a bunch of the text and I read them again. I don't know, whenever she posted them. You got to get this in. I don't care if you got to call Proctor. I don't care if you got to call every single person on that text chain. You got to get these texts in because they are so bad. They are so bad.
The infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
You can take care of it and email it in.
We'll do that. Thank you, Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
This witness has no memory.
I think Yanni made a good argument. Some of it I agree with, some of it I do not. Jen said, Bev mentioned to the lawyer to have his client back in court first thing Monday. Would she do that if she was going to not let him testify? So first off, I don't think she's going to say he can't testify. It's just, is that witness, Proctor's friend's witness, enough testimony to get these text messages in, or do they also have to call Proctor? And you'll catch it more here with Brennan's argument.
Of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context.
So he's saying basically he's fine with these. He knows these texts are probably going to come in, but they got to come in the right way. Be your own strong. Yes, I think he was a very neutral witness. I agree. Sarah, will Hank Brennan lose the jury by being a jerk? Only the jury can tell us that. Number 1 bailiff, have you rectified your question of Karen's phone connected to the Wi-Fi at John's house? No. Doesn't fit the Commonwealth's timeline, that's for sure.
Context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay. It's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias. Perhaps the person was very biased and made decisions based on that animus. Or
do we think that that's what Michael Proctor's going to say? Basically, Brennan's saying Proctor needs to be afforded the opportunity to explain himself. I wanted to be able to explain himself. And I'm telling you, I'm not worried about Proctor explaining himself. Higgins, I think Higgins can make it seem less bad than what it feels like right now. I've said that all along. Proctor, how's that guy going to explain these text messages? And this is Brennan saying, call him. I dare you to call him. And we're going to talk about that after we finish these arguments.
perhaps the person made negative comments, but had nothing whatsoever to do with the investigation. it is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant? Is it material? And what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer, but it should be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context, suggesting it has a value that has not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because
he's just dead wrong about that too. It's like they make these arguments. I don't think this is going to win or lose the day, but that's what lawyers do with every piece of evidence. We argue how we see it in closing. We want the jury to infer certain things from it, right? So I don't care what Proctor says. We as the lawyers, if we're going to ask Proctor about that as the Commonwealth, right, we're going to say that doesn't make him biased just because he said that. And you can make that argument if the texts come in. We as the defense, if you're the defense team, will say he is a jerk. He is biased. He is doing this against her. That's what they mean. It's the same piece of evidence. Lawyers are going to argue it both ways. So for Brendan to be like, well, we can't, as if Proctor coming and denying that is going to change how the defense argues. It's just not. All right, let's get to some Proctor questions. We still have some more of the argument to hear. Do you think the defense is concerned Brendan will lead Proctor through a first draft of closing argument? Brendan has proved he will stop at any level, and Bev has proved she will facilitate it. I think the defense should expect him to do that. That's already what he's done with Buchanan. That's already what he's done with the medical examiner. He's already done that. Why would that make them afraid? And Brendan is going to argue that's exactly what, Yannetti's going to argue that's exactly what Brendan is going to do. Who cares? Let them do that with this jerk cop who is fired for his bias in this case. There's just way too much good information you can get out to make the jury hate Proctor and this entire prosecution investigation team. You have to call him, in my opinion. I'm not going to tell the defense what to do. Obviously, they know this case better than I do. You know, Karen Reed trusts them as she should. They've got her best interest in mind. Humongous mistake if they don't call Proctor, in my opinion. Two mistakes, I think. Karen Reed giving interviews and not calling Proctor. Jessica, Peter, calling Proctor trial 1 didn't get her acquitted. Do you agree the defense needs to shake things up by leaving him as the boogeyman? I don't. I absolutely don't. There's two things. You can either let somebody think somebody's the boogeyman like Brian Higgins, or you can prove to the jury somebody's a boogeyman like Proctor because he is. That's how I see Proctor. What's up, Peter? Regarding Proctor, is it really that big of an advantage for the Commonwealth to be able to cross him? I don't think so. I don't. His actions in firing are damning regardless. I agree. And Judge Cannoni is not going to limit what Hank Brandon was going to be able to ask him on direct anyways. I am not scared of the Commonwealth crossing Michael Proctor and leading him. Lead him wherever you want. Lead the leader. Lead the lead investigator. Do you think John's family truly believes Karen is guilty, or they want to blame someone for type of closure? I don't mean to be insensitive. I'd be totally guessing, but it seems like they believe that she's guilty. Ashley D, thoughts on the defense's strategy, recent filings, and witnesses? I don't know about all the recent filings. I don't know if I've seen them all. But I don't know. I mean, DeSorga was fine as a first witness. I think they should call Proctor. I don't think they're going to call Higgins, Alberts, McCabe's. I don't think they're going to call any of them if they're considering not calling Proctor. Proctor seems way more obvious to me. And it does sound like they are going to call Lucky Laughlin. I heard he was in the courtroom. I wanted to send this message during your last live, but was not at my computer. I do think experts should be paid. My issue is Massachusetts are already paying DAs, money for experts last trial, etc. Now paying again. I get it. Do we know why the judge limits close to 1 hour? It's horrible. It's unfair. I don't think she should, but it's even-handed, right? Both sides. How would you describe your experience from being a prosecution versus defense? Do you find that judges lean toward prosecution too much? Yes, always. Even when I was a prosecutor, I thought they made our life so much easier. I was like, they're not going to yell at me as much as they might yell at the defense attorney. It's a totally different ballgame. Prosecutors have all the resources, all the leverage, everything. What would be the advantage to the Commonwealth if the defense called versus the prosecution? They can lead him. They can direct him. They can tell him the answer in the question. They can make it exactly what. So there is an advantage, a bit of an advantage. But with Proctor, I wouldn't care. I really would not be afraid of Proctor. Is it possible the defense calls Proctor after the 4 new witnesses to validate his character, to undercut cross of Proctor, to try and push the Commonwealth to call him first? It's possible that this game of chicken, they're trying to force each other to call him, that the defense wants them to call Proctor in rebuttal, but I don't think that's going to be a winning strategy. All right, let's listen to some more of the argument.
He made a derogatory comment. He didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of defining the value for which this is being omitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I
disagree with that. It absolutely has to do with the investigation as well.
Might get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing to the jury, and it could be unfair for either side, because it will lead to arguments about what it means without a factual basis. And so my position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Okay. Ms. Janetti, do you want to respond?
He ends with, they should call Michael Proctor. And Yanetti's like, I got something to say about that.
I know we're 3 hours late, I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit text messages. That's our choice. And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay. And
It truly sounds like both sides baiting each other into calling Michael Proctor. You should call Michael Proctor if you want to get these texts in. No, you should call Michael Proctor if you want to call the lead investigation in a murder trial. It's unheard of. And I agree with Yannetti, but it's also unheard of to have the amount of evidence and dirt and be able to show Proctor's true colors to this jury. I would not pass up on this opportunity. If I was the defense, I would call him. It is very rare you get a case like this where you have this much shining a light on darkness that is Michael Proctor. You have to let the jury see that. And so they're not just saying, we need justice for John O'Keefe. If it's close enough, let's just convict her. No, we need justice for bad cops, right? We cannot let Michael Proctor be the lead investigator and do this in this case and convict this woman, because then maybe more cops will do it. Let the jury see, let the jury hear, let them make an informed decision. All right, I've got to go. I'm going to hit these questions here and then I'm out. Kelsos, make sure you guys hit the like button before you go if you're going to go as I answer these. Proctor admitted the last trial. He wrote those text messages. So how is this hearsay? Also, why is the friend not remembering relevant? Just because he admitted in the last trial doesn't make them admissible to this trial. And I don't think the friend not having an independent recollection, I don't think that's going to keep them out. If Brennan can use clips from Karen, can the defense use Proctor's text with friends the same way? No. Karen is a party opponent. Proctor is not a party. CJ, Peter, can you go over the motion of the judge to allow Wednesday for the Commonwealth shocker? They asked for all communication between the witness and the defense. I have not read that motion, so I'm not going to be able to go over it now. Michelle, how much notice do you have to give to subpoena? It depends on the jurisdiction and what you're subpoenaing them for. So I'd have to look into this one more specifically that you're talking about, I'm assuming, with this witness. Brian, don't lawyers have to do so much pro bono work a year? Yes, but that has to be legit pro bono work. You cannot expect to be paid, and you can't be paid later for something you called pro bono work now. Mandy, Peter, since they found 2 more people's DNA on John's clothes, can they ask the police to take DNA from the McAlberts to see if it matches? Thanks from all of us. No, it's way too late in the game for that. They should have done it before. How were Karen Reed and Brian Higgins' texts admitted? If these can't be, this guy is at least part of the thread. This guy's at least part of the thread. So I believe that's because it came from, was it Karen Reed's phone or Brian Higgins' phone? And they got it in from the officer that pulled it. I don't know if both sides agreed it was relevant. Both sides agreed to let it be read. Touche. Does Higgins testifying about where he was parked at Fairview outweigh the risk given the 53-foot backup testimony? Does Higgins testify about? And by the way, Karen Reed's text message again, her party opponent. I have not been convinced that Higgins should be called. Siobhan, Bev is famous now. She'll make them call Proctor for the plot. Overall, what are the jurors leaving thinking? Weeks stand out themes. Honestly, I think it's hard for the jurors to even remember what happened weeks ago. Pete, after Welcher dropping in to ask, do seemingly partisan experts adapt testimony to their visible impression of the jury? He seems to look at the jury a lot. That's possible. I don't actually know the answer to that. That's probably a witness by witness thing, but I think that's a good question. Hey, Peter, do you think the defense will end with ARCA? I think they will either be at the beginning or end. I don't think they're going to call ARCA in the middle. Did we get an order from Kim John Canoni? Enjoy vacation. I have not seen an order on this yet. After seeing trial 1 and what has happened so far in trial 2, would you ever want to lawyer in Massachusetts? There are a lot of tough jurisdictions. It's not like I would shy away from it. Yes, I have cases in Massachusetts. They're civil, but I have them. How relevant is this trial to all citizens? Given 2 hours of my pay to free Karen Reed, I'm sure John's spirit is guiding you. Sweetheart, peace. Donor from online Karen Reed fundraiser, significant, not to so many. I think it matters, right? The judicial system, law enforcement, lawyers, judges, it matters to everybody. So I get why people are fully invested in this trial, because you should want fair cops, a fair judicial system. You should want this transparency. The public should be heard. BB, I've heard Proctor is not available in a fanatic out of country. How does that get remedied? He would have to show up. There's no way he can just be unavailable. I don't think, I'm not giving any credence to that until I hear it confirmed. And I don't hear either side making that argument. Peter, why do you guess the defense might not want to be the one to call Proctor? I mean, he just said it. They don't want Brandon to be able to lead Proctor through his closing argument. I personally don't think they should fear that, but that's just my opinion. Okay. This is the first trial I followed so closely. It was very surprising to me that the prosecutor would want to keep out evidence that could prove the defendant not guilty. In for a win. Heading to work, pizza and chat. See y'all Monday. See the NP. I don't understand why the defense would care about calling Proctor. Brandon has been allowed to lead every witness so far. Good point. On direct and cross without any repercussions. Confused on why the defense cares. And you'll be able to get up in closing and say, they wouldn't call him, so we did because we wanted you to see these text messages to shine a light on this darkness. I mean, that just goes such a long way to me. Will Bev allow the text in through P's friend? I don't know. I don't know the answer. I don't know the answer. And frankly, if she makes him call Proctor, I don't think it's the worst decision she's made in the trial. Thank you, Paul. All right, last one. Hi, Peter. In my opinion, the Commonwealth has proven beyond a reasonable doubt that it will pay top dollar for unprofessional, unethical attorneys and experts, and there are unprofessional and unethical attorneys and experts wanting to work. Hank and his expert should be embarrassed. All right, that's all I got, folks. Love you all. Please hit that like button. Thank you for hanging out with me this Saturday morning. I hope everybody has a wonderful weekend. But for now, I am out of here. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.